Hey, so in this video, we're going to talk about what questions you should expect to be asked in the initial conversation that you have with your potential estate planning attorney. I'm Paul Rabelais. I'm an estate planning attorney. I've helped many thousands of people over the last few decades get and keep their estate legal affairs in order. And this is an area where a lot of attorneys mess it up. So I'm going to tell you what to kind of watch out for. Now, some consumers get nervous before they go see the estate planning attorney. They don't really know what to expect and they don't know if it's going to be painful or difficult. So I hope that this video can give you some expectation so that you don't have to worry that it's going to be something that's really difficult. But before we get into what kinds of questions the attorney is supposed to ask you in order to put a program in place that's customized for you and your family, I want to lay some ground rules. Because if you notice some things right off the bat, you need to stand up and leave. So one, if the attorney talks the whole time, stand up and leave. So unfortunately, that happens a lot where, attorneys, for whatever reason, they like to hear themselves talk. How in the world will they be able to customize a program that fits your needs if your needs are never uncovered? If the attorney talks the whole time, get up and leave. Number two, if the attorney talks in terms over your head, get up and leave. If the attorney talks in terms of Q-tip, Cupert, CRUT, grit, grat, charitable remainder trust, all these terms, you have no idea what they mean. You don't understand what he's saying. Don't be that person who comes to me or someone later and says, I had no idea what the attorney was talking about. He just put some papers in front of me and I signed them. Don't be that person because it's not likely to be what you want. So, and then lastly, this is for you to judge. If the attorney doesn't listen to what you have to say, get up and leave. Somebody told me a long time ago, we have 2 ears and 1 mouth. So the attorney should be listening most of the time, not talking most of the time. So just a few ground rules. Once you get past all of that, now let's talk about the questions you should expect to be asked when you have that conversation with the estate attorney. You've worked your whole lifetime, you've worked for decades, you've raised kids, grandkids, saved, sacrificed, struggled. Now it's time to leave that legacy. You want to make sure you leave it right. So first question I always ask right out of the box, because it's really an important one, is what do you want to make, and that question can come in several different forms. What do you want to make sure you talk about in this discussion about, your estate planning and getting your legal affairs in order? Or, what do you want to make sure you get addressed? Or are there any special questions that you want to make sure get answered as part of this initial conversation? So my job is to ask you a question to pull out of you what kinds of things are important to you. For some people, they've got a list. For some people, they got nothing. So some people have some specific concerns. I hear all the time, husband and wife come in. Paul, we have children from our prior marriages. We want to make sure we get that part of it straight. Or they might say, Paul, we have a child that is fill in the blank, on drugs, can't handle money, been divorced 5 times, and he's married to a floozy. So they want to address that. Some people might say, well, we want to leave a specific thing to a specific person. We want our house to go to our daughter, etc. Or some people just say, we want to make sure our children are treated equally. Some people say we want to provide for our grandchildren, or they might get specific. We want to provide for our grandchildren's education because if our children have to do that, we're not sure that our grandchildren are going to be educated. We want to make sure that they at least have an opportunity to get an education. So some people have specific concerns. Some of those concerns that you have may seem minor to others, but they're important to you. Many times I've dealt with people, multi-million dollars, big family, lots of tax concerns, but their number one thing is making sure that, a grandchild gets the Mustang car. So that just was on their mind. So, the attorney doesn't know unless they ask. And so real important there. Now, some people want to ask, what do you want to make sure we talk about? They look at each other and they're like, we've never been through this before. We don't know what questions to ask. And we just want to make sure our legal affairs are in order. And that's an okay answer too. So real important right at the outset. attorney needs to kind of start pulling out from you what's important to you, and the attorney needs to listen to that so that they can ask the next important question based on the response that you gave them. Again, some attorneys aren't very good listeners, and they're waiting for you to answer so they can start blabbering again, rather than listening to your answer so they can ask the next appropriate question, which might be something like, well, why is that the most important thing to you? Or, why do you want to leave that to that child? So anyway, attorney needs to ask questions, listen, and ask the right next question. But in the beginning, get the framework for what you want to make sure gets addressed. Then there's just some generic questions that are going to be asked in every single conversation. And I'm assuming a conversation with a married couple here, and it will be adapted if it's a single person or any other special circumstances. So, talking to that married couple, and maybe we got a lot of what's most important, out of them. We also need to address just some generic questions. And sometimes I say, well, it's easy if we start at the end and work backwards. So after you both pass away, how do you want what you have left to go? And for some people, really simple. We want it to go to our children equally. And then other people have all kinds of different thoughts and ideas about what they want to accomplish and how they want to leave things. Sometimes I'll ask the question, so after you both pass away, is the distribution in your mind going to go any way other than your children equally? So, because, the children equally is just common. But some people want to leave things to grandchildren, specific bequests, to church, charity, whatever. So we need to find out all of that. And then the conversation usually goes toward, if you have to put someone in charge of that distribution, who do you want it to be? So this could be the executor slash trustee conversation. Is it going to be a child? Is it going to be more than one child? How will those decisions affect children who are not selected? We got to just talk through all of that and make sure you come to a decision that you have, really peace of mind with. And then, we kind of work back from there. Okay, so that's after both of you pass away. Well, how do you want things to be left to each other when one of you passes away? Because there's a couple of really important distinctions. Sometimes, one spouse dies, they just want to leave it all to the surviving spouse. And that's real simple to understand. But some people perceive a potential downside to that is when one spouse dies, it's all left to the surviving spouse. The surviving spouse could, in theory, leave the entire estate to someone other than the children. So, for example, if the surviving spouse remarries, they may leave the entire estate to their new spouse. Doesn't happen much, happens sometimes, but it could happen. So some couples want some protections in place for the children so that the surviving spouse can't divert the entire estate to people other than the children. So we got to have that conversation about what happens when the first spouse dies. Then, other kind of generic topics are, if you're ever incapacitated, who do you want being able to make your financial or medical decisions? And so it's a complete nightmare to everybody involved if you become incapacitated. Maybe you get in a car wreck and your IRA needs to be dealt with. You have a vehicle in your name that can't be transacted. Families often find themselves in this guardianship interdiction proceeding. It's worse than probate. So you can address all that by naming the right people. Most married people, they want their spouse first, but you always need to name a backup. So that might be a child or children. And there's decisions for medical reasons. There's decisions for financial you'll make to state who can make your financial decisions. Got to get all that addressed. Probably going to have some kind of discussion about your desires and your written statement, your written living will statement regarding life support machines and whether you'd want to direct your family and doctors to withhold or withdraw life-sustaining procedures if you're in that vegetative state with no chance of recovery. Some people want to make that decision because they want to keep their children from having to make that one end-of-life decision. All right, and then there's probably going to be a conversation about do you want to make all of these bequests that we discussed through your last will and testament, leave everything in your name, get your wills structured right, but when you pass away, because there's going to be assets in your name, they'll be frozen and your survivors will be forced to go through the court supervised succession or probate process where there'll be court and government and attorney involvement, likely to be delays and expenses that people don't expect? Or would you rather set things up in a way, perhaps in a revocable living trust, so that when you pass away, things are titled in the name of your trust? Your trust really replaces your will. Things in a trust don't have to go through that court-supervised probate process. That successor trustee of your trust that you named will be able to immediately disperse the assets without having to go through all that court and attorney involvement, delay, and expense. So there'll be a conversation about that. Some of the things that I'm not addressing in this video that are important to address in the right circumstances, because the things I just went over, they were addressed in virtually every estate planning conversation. Things I didn't address were things like Medicaid planning. Being real general here, but that middle class is, many of them are worried that if they have to go into a nursing home, they're going to lose their life savings, potentially lose their home. So they want to engage in some special conversations, perhaps even some special legal planning to protect that from happening. Other people have to engage in a little bit more complex estate tax planning. Not many, but some do, because at the time that I make this video, people can leave $11.4 million of an estate free of the estate tax. Married couples, it's really $22.8 million. So it's not a conversation we have. 99% plus of the clients that we deal with don't have to worry about any special estate tax planning, because their estate is not that large. Those are some really large exemptions. And then also, we haven't talked about some of the potential charitable bequest planning. There's a small fraction of people who want to do something for their charity, their favorite charity or charities, their church, their school. And so there's unique conversations about that. And also, what we didn't discuss was the creation of entities, often for liability protection purposes. I don't want to get sued and have somebody wipe me out. It's a common conversation with people who own one or more pieces of rental property. And even though they have liability insurance, they're worried, because all that property is in their name, that if a judgment exceeds the liability insurance, or they are sued for something that they're not covered with insurance for, then they personally could lose everything they have. So again, another kind of unique conversation. And there's many more unique areas that we have to focus in on based on that family's and that individual or that couple's specific needs. But that should give you an idea of what to expect. I'll leave you with point number one. Got to work with the right attorney who doesn't talk the whole time, even though I've been talking the whole time on this video. Unfortunately, I can't listen, but I can read your comments. So I'd like to find out from you in the comments, what are you looking for from an estate planning attorney? And maybe some of the consumers and attorneys out there may read those comments and get some benefit from it when we find out what consumers are really looking for when they're having this important conversation about how they're going to leave that legacy, to their survivors. So number one, work with the right attorney who doesn't talk too much, who listens, and doesn't talk in terms over your head. Expect to have a conversation and expect to do a lot of the talking, because the attorney needs to be listening and asking the right questions, because we need to hear from you what's important, so we can take what's important to you, put it in the framework of what our laws permit you to do, and have it customized to meet your specific needs. So expect to do a lot of the talking, but it should be a really pleasant conversation where you talk about your past and the present and your expected future, and you get to control a lot of these things. It should be something that's really exciting for you to take care of you and get that peace of mind. Okay, comments below. What kinds of things do you expect from that attorney in that initial conversation? Write in the comments below. Hope this helps. I'm Paul Rabelais. Go out and take care of all these legal affairs. We'll see you next time.